In the previous lesson, we took an introduction to the tort of negligence. We explained essentially what the key characteristics are when it comes to determining whether or not negligence existed or whether or not an individual can be found liable for their negligence. And we noted quite interestingly that the key components of negligence include a duty of care, a breach of said duty, and then the action or omission in some circumstances to lead in causation to the harm in question. Now, this lesson is going to start unpacking the first of these major elements, which is this idea of a duty of care. So we will be taking an introduction, if you will, to the subject of a duty of care within the broader context of the subject of the tort of negligence. We'll be spending the majority of this case arguing and looking at an examination of what is arguably the most famous case in all of English law, which is the case of Donoghue and Stevenson. And we'll explain why this case is so important for the principles of the duty of care that it enshrined, and we'll also take a little stroll down the facts of this case as well, for those of you who don't know it, but I would be surprised if anybody who's watching this video does not know about the facts of the case of Donoghue and Stevenson. So, when it comes to the duty of care and an examination of how the duty of care develops within the law of tort from a historical perspective, we can actually see that it begins its life as quite a limited doctrine, as quite a limited principle, because it was only really limited to contractual relationships. And so as a result of which, you have a legal duty to take care, but this legal duty to take care only arises in circumstances where the individuals in question are under a contractual obligation, and so this legal duty exists only through this contractual obligation. Now, the scope and reach of the duty of care would be challenged in this regard in the case, one of the most famous cases in English law, the case of Donoghue and Stevenson, because what arose were facts which would suggest that a duty of care probably ought to exist, but that there wasn't a contractual relationship between the defendant and the claimant in this regard. So how can we either reject the claimant's arguments and reject the claim that was being issued, therefore maintaining this quite limited contractual understanding of the duty of care, or alternatively adjusting this concept of the duty of care to extend beyond that of mere contractual relationships. So that's really what we talk about in the case of Donoghue and Stevenson. Let's begin by thinking about the facts of this case. The facts involve a Mrs. Donoghue and one of her friends who allegedly visit a cafe by the name of Minchella. Now, one of the things that's important to note here is that the facts of this case were never actually challenged in the kind of way that you would in an actual case. Because the legal issues of the duty of care and all these different things went straight up and appealed up to the House of Lords. So what's quite interesting is the actual facts were never proven as to whether or not this happened. So we're going to say that these are the alleged facts which take place. We're just going to assume that they are true for the purposes of this series of lessons. So we have Mrs. Donoghue and one of her friends visiting a cafe by the name of Minchella. At the cafe, the friend of Mrs. Donoghue would purchase for her a ginger beer float, which is a type of drink, essentially. And this ginger beer float would actually arrive in an opaque bottle. That is also something that is important to note. Make it very clear, look, that what we're talking about here is a bottle that was bought by the friend of Mrs. Donoghue and then given to her. So she was the one who made the purchase. Mrs. Donoghue would then drink some of the ginger beer before her friend discovered, upon topping the drink and tipping out the insides of the drink, that what was inside the bottle was the remains of a decomposing snail. Obviously, Mrs. Donoghue isn't particularly happy about this set of affairs. She's drank some of the ginger beer, of which there was a decomposing snail within it, and upon seeing the snail, knowing that she had drank from that, it had made her ill. Okay? So these are the facts of this case. The issue for litigation in this case was who could Mrs. Donoghue sue? Because if we think about the limited duty of care that existed previously within contractual relationships, well, Mrs. Donoghue didn't have any contractual relationship with Minchella, with the people who ran the cafe, because the bottle was bought by her friend, not Mrs. Donoghue. So there was no claim there. In addition to this, Minchella didn't have any liability because there was no duty of care in the fact that they had received the opaque bottles already sealed and was in the process of didn't make any final extra checks, and it would have been impossible for them to make any extra checks as to the contents of each of the bottle anyway. So instead, Mrs. Donoghue made the decision to sue the manufacturer of the bottle. And in addition to this, the retailer, like I just said, could not have been at fault because they were unable to check and see the contents of the bottle themselves. It was an opaque bottle. So Mrs. Donoghue would go on to sue the manufacturer, who obviously didn't have a contractual relationship with Mrs. Donoghue. We have sort of two levels removed. The manufacturer had a contractual relationship with the retailer, presumably, and then the retailer had a contractual relationship with the friend of Mrs. Donoghue, but then Mrs. Donoghue was given the bottle as a gift or as a purchase for her. And so as a result of which, this idea of Mrs. Donoghue making a claim against the manufacturer cannot be done on the basis of a contractual obligation because there didn't exist any contract there. And despite this being the case, she would ultimately win her case against the manufacturer. And this was seemingly relatively innocuous, seen as a relatively innocuous decision made by the House of Lords. However, it was the word of Lord Atkin which enshrines one of the most important principles of the duty of care, and this is known as the neighbour principle. And this is the passage that we can see from which we can find the neighbour principle. They say that the rule that you are to love your neighbour becomes in law, you must not injure your neighbour. And the lawyer's question is, who is my neighbour? Receives a restricted reply. You must take reasonable care to avoid acts or omissions which can reasonably foresee would be likely to injure your neighbour. Who then in law is my neighbour? The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called into question. Now, what the neighbour principle does is essentially generalises the principle of the duty of care. No longer is the duty of care very specifically limited to this idea of there being contractual relationships. Well, now the duty of care is generalised. It is now a generalised principle to your quote-unquote neighbour. And so the neighbour principle, as stated on the previous slide, has with it two interesting components. We have this idea of reasonable foreseeability, and then we have this idea of proximity. These two elements of the neighbour principle essentially expands the legal duty of care beyond that which is just contractual relationships. And what we will see in the next lesson is this case essentially being picked up by subsequent cases. And there has been something of an expansion of the legal duty of care, and then a restriction of the legal duty of care, and a sort of reformulation to the point where we have the principles that exist today. So we're going to get into that as we look at the development of this principle of the duty of care in the next few lessons' time. In the previous lesson, what we did was introduce the subject of the duty of care, which we remember was the first major element that is required for the establishment of negligence in the law of tort. This lesson is going to talk about how we took the basic principles, which essentially generalizes the duty of care outside of the contractual relationship in Donoghue and Stevenson, and we talk about how this develops over time into what we will talk about in the next lesson, which is how the duty of care is viewed today. So, the landmark case, of course, which begins the majority of this story, is, of course, the case of Donoghue and Stevenson. We noted in that lesson that the general duty of care, which takes out of the contractual relationship, is established in Donoghue and Stevenson, or it is at least discussed in Donoghue and Stevenson. We have Lord Atkin's neighbour principle. And what the neighbour principle essentially tells us is that the duty of care, the love thy neighbour, in law translates to a duty to not harm one's neighbour, which means that there doesn't necessarily have to be a contractual relationship between the claimant and the defendant in order for a duty of care to be established, because of course the facts of the case of Donoghue and Stevenson, there existed no such contractual relationship. And so as a result of which, we start to see the way in which the development of this principle takes place. The case of Donoghue and Stevenson ultimately opens the door to various other principles of the duty of care. The principle at the time was relatively untested, so the possibility for the scope to either expand or contract was something of an open question. Whether or not the Donoghue and Stevenson neighbour principle was correct, whether or not it needed to be more broad, whether or not it needed to be more restricted, whether or not there needed to be more elucidation of the principle to essentially establish good law on the matter. What we actually see is something of an expansion and a contraction of the principle of the duty of care as it begins to develop. So let's begin with the first of these cases. Let's start by talking about the 1964 case of Hedley, Byrne and Heller. The facts are as follows. The claimants in this case were an advertising agency, and they were looking for information about whether or not one of their potential clients was creditworthy. The client was Easy Power. So the question was this potential client, which we may be putting in a lot of money and maybe business risk into advertising for, were they creditworthy such that they could pay off their debts, for example? Now, what they attempted to do was to try and get this information from the potential client's bank, the potential client's bank being the defendant in this case. Now, the bank would give them a favourable credit reference for Easy Power, for the corporation, which then therefore incentivized the claimants, the advertising agency, to enter into a contract with Easy Power to do their advertising. When Easy Power then went into liquidation, the claimants would lose around £15,000, which in 1964 is a significant sum of money. I mean, it's a significant sum of money today, but even more so in 1964. And so as a result of which, they sued the bank for negligence, for negligently providing a favourable credit reference to Easy Power. And as such, the breach of that duty of care causes the claimants to lose £15,000. It was held by the House of Lords that the defendants were actually not liable in negligence. There was no liability to be had. The response from the bank upon the request for the information about the creditworthiness of Easy Power included a disclaimer which says the following: "For your private use and without responsibility on the part of this bank or its officials." Okay, so they essentially hedged their bets in making very clear that the creditworthiness rating, the favourable credit rating that the bank gave, was one which was without responsibility on the part of this bank or its officials. So they gave it a favourable credit rating, but essentially made it very clear to the advertising agencies, the claimants, that this is what we believe to be the creditworthiness of this company. Use this information at your own peril. It is not our responsibility if you use this information, and therefore, and as a result of which the company goes into liquidation and you lose money. The House of Lords argued that, but for the issuance of this disclaimer, the bank may have been negligent for the statement that was made. So this disclaimer actually protected the bank against a potential negligence claim. In 1970, we see another case, another very landmark case, the case of the Home Office and the Dorset Yacht Corporation. The importance of this case rests on the fact that a duty of care is imposed on a defendant, but not from the actions of the defendant, but from the actions of third parties, which the defendant had a duty to take care of themselves. So that's what's important about this case. It then extends the duty of care not only to the actions of a single individual or a single defendant or a single institution, for example, but for the actions of third parties for which the defendant is responsible for. The facts are as follows. The Home Office had established a borstal. Now, a borstal is just a relatively old-fashioned word, in fact, for a place where young offenders will go and work, like a sort of not re-education in a way, but a sort of rehabilitation place for young offenders, a young offenders institute, if you will. Now, those trainees in question, the people who were the young offenders working at the borstal, had been working at a harbour. While they were left unsupervised by their officers, which was a breach of their instructions, the officers had been told to keep an eye on these young offenders, but they had breached their duty in doing so. One night they had then escaped, and then while they were unsupervised, they went and caused some damage to a yacht which was moored in the harbour. So ultimately, it was held that a duty of care existed between the Home Office and the owner of the yacht. And there was proximity in the sense that they were working in the harbour, so they were close to the action, if you will. And it was reasonably foreseeable that this is something that could have happened if they were left unsupervised. So not only did they have a duty of care, in the sense that they had a duty to take care to ensure that these young offenders did not go off and cause mayhem, essentially. This was a breach of their instructions because they did leave these individuals unsupervised. But in doing so, it was reasonably foreseeable that if they had done so, then this could have happened. This kind of damage would have taken place. And so as a result, this establishes the principle that a defendant who didn't do the harm themselves, it wasn't the Home Office, for example, or the people who were working at the Borstal who caused the damage. It was the young offenders who caused the damage, but the young offenders were under the responsibility of supervision by the officers who were working for the Home Office. A few years later, in 1978, we have the case of Ans and Merton. The claimants in this case were the lessees of a block of flats, which ultimately had some faulty foundations, and that the faulty foundations would lead to cracks being found in the buildings themselves. Merton LBC was sued for breach of their statutory duty in essentially approving the foundations, where it was very, very clear that they were not deep enough, and this kind of thing was probably going to happen as a result of the poor management and the poor decision to approve of the foundations in the building of these flats. It was held by Lord Wilberforce that a two-stage test should be made for making a determination where a duty of care exists in these circumstances. So we're starting to see a development of the duty of care in this example, because what Lord Wilberforce suggests is answering these two questions. And if you can answer these two questions in this two-stage test, then we can establish a duty of care in these circumstances. So the first question is there a sufficient amount of proximity or neighbourhood between the claimant and the defendant such that the defendant should reasonably foresee that their actions would be likely to cause damage to the claimant? What Lord Wilberforce is doing here is essentially reformulating the neighbour principle that was established by Lord Atkins in Donoghue and Stevenson, but doing so with a little bit more legalistic rigour, if you will, to ensure that the test is a little bit more substantial, rather than just waxing lyrical about the love thy neighbour principle. What this does is asking the question of whether or not there is a sufficient amount of proximity or neighbourhood, how close you are to the defendant, and that there was a reasonable foreseeability that the actions in question would likely cause damage to the claimant. And then the next question is, were there any considerations which may limit or even potentially negate the duty of care to be found? So the first question is establishing whether or not the duty of care exists. The second question essentially asks if there were any considerations which could potentially negate said duty of care. And we see here that still it is the case by Lord Wilberforce that the neighbour principle is sort of reformulated in a way, but still includes this idea of proximity to the defendant, as well as the reasonable foreseeability of their actions. This case would ultimately be altered, and the claim for actionable damage and negligence would later be rejected in the case of Murphy and Brentwood, DC. And we're going to get to this in the next lesson. But ultimately, what this lesson has essentially done is talk about how the duty of care as a generalized principle can be extended in the case of, for example, Dorset Yacht, and then reformulated in Ans and Merton, and then we have to then get to the cases that are more modern when we're talking about how the duty of care is approached today. So talking about things like Murphy and Brentwood. We also have a number of other ones that we're going to look at in the next lesson as well, to talk about how we establish a duty of care today. Not only establish a duty of care on the basis of previous precedent, but also establish a duty of care in novel cases, in new circumstances where no previous case precedent exists. In the previous lessons, what we looked at was the establishment of a general duty of care when it comes to cases of negligence in the examination of Donoghue and Stevenson, as well as the development of the principles of the duty of care, going through a number of cases, including the case of Dorset Yacht, as well as the case of Ans Merton. Ultimately, what we're going to do today is talk about how the duty of care is operationalized in today's litigation, how it operates with the modern cases that have established principles. Now, we're going to look at how the duty of care is established in sort of general cases, and then also talk about how the duty of care is established in novel cases. So what we mean by novel cases of a duty of care are cases where there is no previously established precedent. So where there are factual circumstances whereby we cannot apply the law of a previous case to that particular example to try and establish whether or not a duty of care existed. So like I said, we have spent some time examining the historical development of the duty of care, looking at how it develops from the case of Donoghue and Stevenson, and then applied to numerous other factual situations and new circumstances. And we're going to begin, like I've said, by looking at the duty of care as applied in novel circumstances, in novel cases. And one of the examples that we can look at is the case of 1990, in the case of Caparo and Dickman. Because what Caparo and Dickman does is give us a test for how one ought to approach the issue of establishing a duty of care in novel circumstances. So what we're talking about, as I've mentioned, is circumstances where there is not a previously established precedent. So for the most part, in a lot of circumstances, when we're applying the duty of care or asking the question of whether or not a duty of care exists, we can just defer to previous case precedent, and we can see other cases that are similar, where we can apply to the similar facts of those cases, and we can therefore establish whether or not a duty of care existed. But what about circumstances where the facts of this case are completely new, and there are completely new circumstances that we need to think about how to apply the duty of care to it? Well, in the absence of any case law authority, one ought to follow the Caparo and Dickman test by looking at the three establishment criteria. So they must ask the question of whether or not the damage in question was foreseeable on the part of the defendant, whether or not there was a sufficient amount of proximity, and if a duty is to exist, would that duty be fair, just, and reasonable? So given foreseeability and proximity, which are tests which derive out of the neighbour principle of Donoghue and Stevenson, and then given those two facts being established, if we were to apply a duty of care in those cases, would that situation be fair, just, and reasonable? That is how Caparo and Dickman establishes a principle of duty of care when it comes to novel cases. However, the application of the Caparo test has been difficult in recent examples and in recent cases, and arguably the most recent of this is the case of Robinson and the Chief Constable of West Yorkshire Police from 2018. Now, this case is quite interesting. So the facts of this case are as follows. The claimant was an elderly woman, Robinson, who had been knocked over by two police officers who were in the process of trying to apprehend a drug dealer on a high street. That is essentially the setup to this series of cases, to this case specifically. There was a drugs bust essentially being established in a relatively busy high street, and the elderly woman was knocked over when the two police officers were trying to come about establishing this, this case. They were trying to essentially apprehend this drug dealer. Now, the two officers did note that the old lady was in the vicinity of this potential drug bust. So there was this potential that existed here. And ultimately, it was held that in the application of the Caparo test, if we were to apply the Caparo test for a case of a duty of care, the Court of Appeal believed it would not satisfy the third criteria to apply a duty of care onto police officers, noting that it was not fair, just, and reasonable. So we looked at the three principles, the three-stage test, if you will, for the case of Caparo and Dickman, and we looked at the question of foreseeability on the one hand, and then proximity on the other hand, but then we came to the conclusion, according to this case, that it would not be fair, just, and reasonable to apply a duty of care onto police officers trying to go about their duty. So that's where it was essentially left. It then went and appealed to the Supreme Court, where the Supreme Court overturned this ruling, noting that the police officers did actually have a duty of care to the claimant, to the elderly woman who was knocked down in the process. They said that in cases where the question of whether a duty of care arises, and in those cases where it has not previously been decided, so specifically we're talking about novel cases, the duty of care in novel cases, okay, the courts will consider the closest analogies in the existing law, with a view to maintaining the coherence of the law and the avoidance of inappropriate distinctions. They will also weigh up the reasons for and against imposing liability in order to decide the existence of a duty of care that would be just and reasonable. In the present case, however, all that is required is the application of particular circumstances of established principles governing liability for personal injury. That is the establishment that we find. And this is something that is discussed even further when we talk about another case that takes place in and around the same time, the case of Darnley and Croydon Health Services. The facts of this case are interesting. Essentially, the claimant had gone to an NHS accident and emergency service after having sustained a head injury. Now, he was told by the receptionist at the desk an incorrect waiting time. The information ultimately led him to return home. So he goes to A&E, he says, I've got a head injury, and the receptionist makes a mistake. The receptionist says it gives them a waiting time, which is actually incorrect. It's a much longer waiting time than was actually the case. And the information being told of the waiting time had led the claimant to go home instead of sitting around and waiting for being seen by the doctors at the NHS. And then when he came back to the hospital a few hours later, he had sustained a permanent brain damage, which would have been avoided if he had stayed in the hospital originally, because in reality, he was given the incorrect time. So he would have been seen to much quicker than he had anticipated, because the correct time was much shorter than the one that was relayed to him by the receptionist. And so as a result of this, he had suffered permanent brain damage. And at the trial level and the Court of Appeal level, the claim was dismissed on the basis that there was no duty to advise about wait times. So the argument was essentially presented that the receptionist had a duty of care to advise a correct wait time, and they had breached that duty in doing so, which had caused the permanent brain damage as a direct but-for application. The Supreme Court, on the other hand, looked at whether the duty of care had been breached, and it was held that a duty of care had been breached, and that the chain of causation had not been broken by the claimant leaving the hospital, because ultimately the claimant leaving the hospital was part of the chain of causation, because that's what led to the brain damage in question. They say that the present case falls squarely within an established category of duty of care. It has long been established that such a duty is owed to by those who provide and run a casualty department to persons presenting themselves complaining of illness or injury, and before they are treated or received into care in the hospital's wards. The duty is one to take reasonable care not to cause physical injury to the patient. Moreover, the scope of the duty to take reasonable care not to act in such a way as foreseeably to cause such a patient to sustain physical injury clearly extends to a duty to take reasonable care not to provide misleading information which may foreseeably cause injury. So the receptionist gave misleading information, was negligent in the application of this misleading information, and the result of which was that they had sustained physical injury owing to the application of this misleading information. In continuing our conversations about the tort of negligence, in this lesson what we're going to do is talk about the concept of foreseeability. We'll explain what foreseeability means in a little bit more detail, given how important foreseeability is to the fundamental bedrock of the tort of negligence. And then we will explain, or at least provide some further reference from the case of Alcock. So the last few lessons we've been examining the nature of specifically the duty of care for the law of tort, specifically applying this to the tort of negligence. And we noted that one of the issues at hand in relation to establishing a duty of care, a duty to take care, is this idea of the concept of foreseeability. So what does foreseeability mean, and why is it so important? Well, it's fundamentally the bedrock of the law of negligence within the concept of the duty of care, and it's also something which enshrines an objective test. So not one which is subject to a particular defendant in question. And this is good, this is useful, because it allows for courts to apply the law in a more objective and predictable manner. So the concept of foreseeability is not one which is whether or not it was relevant for you as a specific individual to have foreseen an event taking place at the time. The concept of foreseeability is a test which is done on the basis of what is known to be a reasonable person, and how a reasonable person ought to have foreseen in the circumstances. So what that reasonable person ought to have foreseen. And so this is delineated from what the defendant in the case actually did foresee, or what the defendant specifically ought to have foreseen. It is what a reasonable person ought to have foreseen in a particular case. Moreover, in addition to this, when we talk about foreseeability, we are talking about foreseeability with reference to a specific claimant. So Lord Atkin, according to Lord Atkin, the concept of a duty of care refers to a claimant who is, quote, closely and directly affected by the conduct of the defendant. This instills the next of the ideas, which is this idea of proximity as well, which we will get to in a second. But when we get to some cases in the future, we'll see cases where there have been attempts to make claims from negligence in which there is said to exist something known as claims in the air. And when we look at the concept of psychiatric injury in future lessons' time, we will see that this is something that's quite interesting to note, and something that the courts have been very, very strong to clearly delineate where a claim can be made versus where a claim might not be made, okay, owing to the events of specific circumstances. Psychiatric injury is very important in that regard because it allows for essentially stretching our understanding of the concept of negligence to the extreme because of the weakening of the links between an action and the psychiatric harm which is caused as a result. In addition to this, then, there is this concept of proximity. Proximity is the second major part of a determination when we are looking at trying to establish a duty of care, a duty to take care. It arguably refers to, quote, the closeness of the relationship between the defendant and the claimant. This is taken from Giliker from 2023. Now, the concept of proximity and the degree of proximity will, of course, differ from case to case, and it would also differ from claim to claim. And one of the most important cases in negligence is the case of Alcock and the Chief Constable of South Yorkshire from 1992. What it says here is that the impracticability or unreasonableness of entertaining claims to the ultimate limits of the consequences of human activity necessarily plays a part in the court's perception of what is sufficiently proximate. Simply put, one of the key tests for determining proximity is that of the policy considerations involved in the process of making said determination. Because one of the main considerations when it comes to policy considerations is whether or not there would be a potential floodgates of litigation owing to the result of a particular case. And where there are potentially thousands of potential claimants in a case of such huge scale and magnitude, it is important that we clearly define and clearly limit what is sufficiently proximate and what is sufficiently foreseeable, or what a reasonable person ought to foresee, such as to essentially limit the number of potential claims of litigation that can actually be brought forward. So the concepts of foreseeability and proximity fall along that similar standard. Now we're going to talk about the concept of the reasonable person in more detail when we look at breach of duty and the standard of care. So we will come back to that in more detail if you feel like we haven't covered it enough yet. But then we will also come across the case of Alcock when we talk about psychiatric harm in far more detail as well, when we talk about specifically the claims for secondary victimhood. We'll get to that in future lessons time too.